Hello, my name is Marissa Layne, and my topic was on the competency to waive the right to counsel and represent oneself. The first section is some key definitions to understand about our topic in order to get a better idea of what defines competency and how that affects the right to waive counsel. The second section is some key cases in competency to waive the right to counsel, including cases that have had a large impact on the legal definitions of the term and how it is implemented in our justice system. The third section of slides is about competency evaluations and how they relate to the competency to waive the right to counsel, especially what our job is as the evaluator doing the exam. The final slide is the media source for this presentation about Lynette Fromm, a member of the Charles Manson cult, and the discussion for this topic. The number one thing to know about representing yourself in the court of law or going pro se is that generally speaking, it is in your worst interests. So as you can see from this post, in my defense, Your Honor, I simply do not vibe with the law. Sometimes what we say in our own defense is not the best legal justification. The first thing to talk about are the definitions. This is decisional competency, the competence to make a particular decision. The state traditionally has the ability to make decisions for those unable to care for themselves. Decisional competence decides if an individual needs the state to make decisions for them or if they're able to make those decisions on their own. Decisional competence decides competency to waive the right to counsel, but it's also included in other competency evaluations, including the competence to consent to search and seizure, the competence to exercise and waive the right to avoid self-incrimination, the competence to enter a plea, and the competence to refuse an insanity defense. And all of this was from the Melton textbook. The next thing we want to cover is some key cases that determined the different rules involved in the right to waive the right to counsel. 4 cases set the precedent for competency to waive the right to counsel and defend oneself, including showing that defending oneself when used is most likely to have an adverse effect on a fair trial and is usually not in the best interest of the defendant. These cases include Ferretta v. California, Godinez v. Moran, McCaskill v. Wiggins, and Edwards v. Indiana. The first case is Ferretta v. California. In this case, an individual was charged with grand theft and wanted to represent themselves instead of using an attorney. The judge ruled that as the individual did not understand legal jargon and procedure, that they were not competent to self-represent themselves. This case ended up ruling and holding that the Sixth Amendment guarantees criminal defendants the right to self-representation, including the idea that the value of free choice is worthy of constitutional protection. It emphasized that the defendant is not incompetent to waive an attorney just because they don't understand technical legal matters, like what determines selection of jury members. The next case that's relevant is Godinez v. Moran. Moran was accused of fatally shooting 3 individuals before attempting to kill himself. Originally, Moran pleaded not guilty before being evaluated by a psychiatrist and changing his plea to guilty, and also waiving his counsel once he had been found competent to stand trial. After being sentenced to death, Moran returned to court and claimed he was incompetent to represent himself, but was competent to stand trial and sought to appeal his conviction. This case ended up finding that competence to stand trial and competence to waive counsel are equivalent levels of competency, and someone who is competent enough to be tried in a court of law is also competent to decide to represent themselves and be pro se. It also ruled that the individual who is requesting the right to waive counsel must be voluntary and knowing, meaning that they are completely aware of the negative consequences of going pro se and are still set on doing so. As a caveat, standby counsel is allowed to be appointed in order to assist the defendant when they request it without interfering with their self-representation, and I talk more about standby counsel later. The third case to discuss is McCaskill v. Wiggins. In this case, Wiggins robbed a store and was charged with robbery and convicted of life in prison, but his conviction was set aside due to a faulty indictment. In the first trial, Wiggins waived his right to counsel, but in the second trial, he filed a request for counsel. Throughout the trial, he had a poor relationship with his standby counsel, and after the trial, he blamed the guilty verdict on his standby counsel and attempted to move for a new trial. This case ended up determining that an individual who waives the right to counsel can still be forced to use counsel as long as they remain in control of the case and the jury is aware that they are self-represented. The counsel that they are appointed works as a standby counsel and provides advice and information about legal rules. So that basically determines that standby counsel is just an attorney that's there to help the individual if they need it, but does not take over the case. The final case to talk about is Edwards v. Indiana. In this, Edwards was arrested after stealing a pair of shoes and shooting 3 individuals. Initially, Edwards was found mentally incompetent, but after multiple years of psychiatric evaluation, he was put on trial. At the retrial, Edwards requested to represent himself. This request was granted initially, but was ultimately overturned when it became obvious that Edwards was not mentally equipped to conduct a coherent defense. After his convictions, Edwards attempted to appeal based on his Sixth Amendment rights being violated. So this case ended up ruling that defendants who are competent to stand trial and waive right to counsel may be required to accept counsel regardless if they, quote, still suffer from severe mental illness to the point where they are not competent to conduct trial proceedings by themselves. And that's a direct quote from Melton. This ruling ended up ignoring the Moran ruling when defendant wants to go to trial rather than plead guilty. And it further did not provide clarification on when someone who is competent to waive counsel is also incompetent to represent themselves, except to say that the inability to carry out basic trial tasks might meet that test. The next thing to cover is the competency evaluations themselves. Normally, the competency evaluations are conducted the same between the competency to stand trial and the competency to waive the right to counsel. Clinicians should be alert to attitudes about the legal process that are red flags of mental disorders or disordered thinking. This can include defeatist attitudes like a lawyer won't help, I'm guilty, paranoid ideation like every judge or every lawyer's out to get me, clearly fantastic objectives like their defense being based on the idea that a murder victim is not dead and is still alive. It can also include irrational beliefs, like supernatural powers that prevent the jury from convicting them, like thinking that Jesus will protect them, or the devil, or something like that. Next is the media source and the discussion. The media source I picked for this topic is about Lynette Squeaky Fromm. Squeaky is just her nickname. This is an article, and it focuses on the competency evaluation of Lynette. Fromm was a member of the Charles Manson family cult and attempted to shoot and kill President Gerald Ford in 1975. Fromm wished to represent herself pro se and self-represent at her own court case while being tried for the attempted assassination. As per the norm, she was given a competency evaluation by the psychiatrist James Richmond. This article includes some excerpts from the tape, along with some additional information about the crime and trial, along with background information about Fromm. If you're interested, there's also an additional optional full transcript of the interview that's 132 minutes long. Our professor actually provided this to us in an optional link in Module 2 as well, but I provided it here also if you're interested. The discussion question is, do you believe that competency to waive right to counsel should have the same level of competency as the right to stand trial? If so, what differences in psyche would you think are important to consider? If not, explain why you think both competencies should be evaluated in the same way. And then here are just some fun facts. 28% in competency evaluations are found incompetent but can attain competency. 3.2% are found incompetent but cannot attain competency, and 65% are found competent to stand trial. And 50,000 individuals undergo competency evaluations every year. And here's my list of references. Thank you.